On the 31st of December 2024, the Ada County Clerk of Court's office released a number of documents onto the public docket in Idaho versus Kohberger. The reply to the state's objection to the defense's motion to suppress regarding the Google warrants. They are dated the 3rd of January 2023, 24th of January 2023, and 24th of February 2023. And basically, it's a really long paper. A lot of it is a federal district court case that Ms. Massoff has highlighted in a certain part to support one of her points. But it's basically 4.5 pages of legal authority. And what she's saying here in a nutshell is, if you go to page 2, the warrants were general, they were not specific, and the affidavit was not incorporated into the 3 warrants or served with the warrants, which is exactly what the federal court in the case that she's citing to and attached. This is from an Idaho district court's relatively recent. Affidavit needs to be incorporated into the 3 warrants or served with the warrants. This portion of her filing cites to the 4th Amendment to the United States Constitution, which states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrants shall issue but upon probable cause, supported by oath or affirmation, and particularity. Can't be general, it must be particular, describing the place to be searched and the person or things to be seized. And she says here, citing to Article 1, Section 17 of the Idaho Constitution, is virtually identical to the 4th Amendment, except that the term oath or affirmation is described as affidavit in Idaho. Basically, what she's saying here, next page, the affidavit of Detective Brett Payne swears that Detective Mallory served the warrant. See Exhibit D, Google memorandum. The email between Mallory and Google references a quote-unquote warrant. See Exhibit F of the Google memorandum. No return documents reference the affidavit in support of the search warrant as having accompanied any of the Google warrants when they were served, nor does the state produce such records. In its objection, the process described by the state as meeting the criteria of State versus Teal simply does not exist in its incorporated objection to the motion to suppress the Apple warrant. This is another warrant. The state indicates that the investigators necessarily had copies of the affidavit in their possession when they executed the warrant by emailing it to Apple. She's arguing that that's not what is required under precedent to meet the requirements of the 4th Amendment and the Idaho Constitution that cites to and is basically identical to the 4th Amendment to the U.S. Constitution. Next page, she talks about the fact that the search warrant fails to provide specific particularity of what to search. So she's arguing that these warrants were not specific either. Finally, she brings up again this Frank's type language that we saw in the reply regarding the pen, trap, and trace motion to suppress. If you haven't had an opportunity to listen to that episode of the Indie Zone, which we published earlier today, please do so. She's saying here that the affidavit submitted to support the application for the issued search warrant recklessly or intentionally omitted material information. That is Frank's type language that is used to suppress a warrant affidavit, not just the evidence, but a warrant affidavit under a Frank's motion. She also cites to the Frank's motion, which is filed under seal. The amended motion was filed back on November 26, 2024. In conclusion, she requests that the court suppress all evidence obtained by police via the subpoenas and warrants, that would be 3 of them, that permitted them to search Mr. Kohberger's Google accounts. This will now conclude this episode of the Indie Zone. If you have any comments, any thoughts, any questions, please leave them below. I appreciate all feedback, all points of view. This is Kathy. Thank you for joining us here today.